So without further delay, thanks again for joining us. We're going to go ahead and get started. My name is Erin Kopek, and I'm the VP of Sales and Marketing with Higher Level. And today we kick off our first webinar series of the year. Super excited to have one of our trusted advisors on the phone, John Gilbert, to join us today, talking about current labor law developments and what you need to know to keep your business in compliance. Always love having the Sandberg team on year after year to provide not only us, but you all on the line with valuable content to help keep your business in compliance and really just give us a thumbprint of what we need to know for the year. So before we kick off, I have a couple housekeeping things that I would like to let you know. And we will have, this call will last less than an hour. You do have the ability to ask questions, and we will do our best to get those answered for you. So feel free to do that in your question pane at the bottom of your GoToWebinar screen. Everyone on the call today is muted, so that is the way you will communicate. So before we get started, I want to introduce John. He has done this. This is probably the 5th or 6th year that he is partnering with Higher Level on our webinar program, so definitely value their partnership. John Gilbert has been practicing law since 1975 and brings a wealth of experience to representing companies in the United States. His firm is located in Edwardsville, Illinois. He is a member of the Business and Business Litigation Practice Groups, focusing on his practice on labor law, employment, commercial, and higher education. John serves as the team leader of the Correctional Medicine Industry team at Sandberg Phoenix. While working with his clients, John dives in headfirst, getting to know all of his clients and businesses. John's favorite hobby is reading, especially mystery novels and academic publications in ethics and business. Thank you again, John, and I pass it off to you.
Good morning. Hopefully everyone can hear me. I want to first thank Higher Level and Erin for giving me the opportunity to speak with all of you today, and thanks for joining us. Before I get into the subject matter, I am required by legal ethics to tell you that this presentation is not intended to be legal advice, nor should you take it as legal advice, because what I'm going to go over in the short period of time that we have, although hopefully it won't seem too long to the participants, we will just touch the surface on some of these current developments and latest developments, both from federal and state law. So if you have further questions, of course, anyone can contact me, but be sure if issues arise under these legal headings, check with your legal counsel, your labor and employment counsel, to guide you through these issues. So today, we're going to talk about, or I'm going to talk about, and if you have questions, we have the chat function, about current developments in labor and employment law. And I want to start with the National Labor Relations Board. As most of you know, if not all of you, the NLRB has jurisdiction over private sector labor relations, but it also has implication for public sector labor relations, because almost every state, especially those that are employee friendly, follows the NLRB precedent. Now, they pick and choose, but it's important to be aware of what the NLRB is doing if you are involved in public sector labor relations. So the NLRB has been very busy the last few months, and if you've been following what's been going on with the NLRB, it's been sort of a seesaw situation, which started when President Obama was in office. He appointed his board and finally got a majority of Democrats who favored his policy and his commitment to organized labor. So during his administration, the labor board implemented in its decisions and also regulations some what we who represent management side like me thought were pretty radical changes to NLRB precedent. And we had to work with those. And we did for the 6 or so years after he got his majority on the labor board. Well, then when President Trump was elected, as you might imagine, he got a majority, got his folks into control of the labor board, and they set about to reverse all the, not all, but many of the rulings from the Obama board that favored labor. The Trump board made things, at least in my view, a little more balanced and returned to some of the older approaches to things, and they had their own slant, which was what they thought was a reasonable balance between labor and employment. Well, you know what's going to come next. Joe Biden becomes president, and he now has a majority on that board, and they're flipping back to the Obama board precedents. So there are some major decisions in the last year that the NLRB has handed down, which has changed the landscape sort of back to the way it was in the Obama era, but they've also gone beyond that. So let me talk about a few of those. First, a decision was handed down by the labor board dealing with off-duty contractor employees' rights to access property to engage in protected activity. That's a mouthful, but what it really boiled down to was, or is, when a property owner, usually an employer who has a plant, contracts out certain work that goes on all the time, full-time contractor employees are present. The issue was whether those full-time contractor employees can return and have access to the employer/owner's property to protest, basically, which is protected activity under the National Labor Relations Act. Well, the Labor Board on December 16th of last year determined that it would reverse some precedent from the Trump era and return to a decision that was made during the Obama presidency called New York test. And essentially, the bottom line on this is those contractor employees who are off duty may return to the premises in order to engage in protected activity, what we call Section 7 rights. Now, they did preserve an out for the employer/property owner, which is that if the employer can meet the burden of proving that there is a significant interference with the property, or there's another legitimate business reason to keep those people who are off duty off the premises, then there may be they may be able to keep those folks off. It's a heavy burden, especially with this iteration of the board. And but they did talk about in that decision, if it interferes with production or in order to maintain discipline, then perhaps the employer/owner of the property can make a showing that would enable that employer to tell those employees to bar them from the property. So it's a much, well, clearer in a sense, but also more difficult task for the employer. Excuse me. The second bullet point you'll see is employee interrogation standards. The board has gone back to pre-Trump board policies and has reiterated its adoption of a case called Johnny's Poultry. It's a case that has been around for quite a while. And the Trump board overruled it. Well, not exactly overruled it, but had a different test. Now Johnny's Poultry is the test. So if you have an investigation, for example, where you have to talk to employees about misconduct of other employees or anything that requires you to interrogate your employees, whether they're union or non-union, because keep in mind, the NLRA applies to any private sector employee, not just those who are organized and belong to unions. So Johnny's Poultry says this, that the test for lawful interrogation of employees is that you have to assure the employee that no reprisal will take place, obtain participation on a voluntary basis. The questioning must occur in the context free from employer hostility and must not be itself coercive in nature. And the questions must not exceed the necessity of a legitimate purpose by prying into union matters, eliciting information concerning employees' subjective state of mind, or otherwise interfering with protected activity. Now, I don't know about you, but in all the investigations I've continued in my nearly 50 years of law practice, we rarely, if ever, get into any union issues. It's generally focused on the information needed to respond to a grievance or to prepare for arbitration or just an internal investigation. But know that the Johnny's Poultry standards will be applied if you get an unfair labor practice charge arising out of interrogating employees, even with a legitimate purpose. In my experience, it's often a typical reaction to when you start talking to employees about internal investigation issues. So those have been reinstated, if you will. One of the major decisions, and this is the item C, one of the major decisions under the Obama board was something called specialty healthcare. And it dealt with the problem of unit fragmentation. What is that? Well, when a union files a representation petition with the boards called an RC petition, the union sets forth the unit of employees it wishes to represent. And prior to specialty healthcare, there was often a contest over whether the union was the most appropriate unit. So you would have, for example, maybe some production employees who the union would petition for, and then the employer would say, hey, that's not appropriate. Some of our manufacturing employees ought to go in there because they have a community of interest. And specialty healthcare, during the Obama administration, that iteration of the board held that no, the statute doesn't say it has to be the most appropriate unit. It has to be an appropriate unit. So that paved the way for unions to organize smaller units to represent. And of course, with a smaller unit, there's a greater likelihood those folks will vote for union representation. And vice versa, the employer wants to put as many people in that unit because more people vote and they have a chance to defeat the union. So specialty healthcare said, as long as it's an appropriate unit, we're good to go. So in a decision that came down December 14th of last year, well, let me back up a little bit. In 2017, the Trump board reversed specialty healthcare. overruled it and went back to a easier, less generous standard for deciding whether union is appropriate, and was a little more employer friendly. And that was the PCC Structurals case. Well, on December 14th, the Biden board reversed that and readopted the specialty healthcare standard, which we were used to dealing with anyway. But it just shows you another example of how political all this stuff can be, and also is a pretty good demonstration of how administrative agencies can shift back and forth on legal questions, which makes it more difficult for employers and sometimes employees. Sorry about that. To be able to understand the law. So under specialty healthcare, basically what we're dealing with is the determination of an appropriate unit is an appropriate unit. It doesn't have to be the most appropriate unit. So the test is now for a petition for a unit, they share an internal community of interest, which has always been the test. Readily identifies as a group based on job classification, department's function, work location, skills, or similar factors, and is sufficiently distinct from those who are not included in that petition for unit. And then finally, the board is going to apply that community of interest factor regardless of whether there's a showing that there's an overwhelming community of interest with other employees who the employer thinks should be in the group. And so we're back to specialty healthcare, and that's an important case because when you have a unit of employees petitioned for, generally the employer wants more employees in there, the union wants fewer so they can try to win the election. Okay, let's go to now one of the major changes, and this is a major change that the board issued in a decision called Thrive Inc. on December 13th of last year. This is probably the most significant decision of the board so far. And that has to do with the expansion of remedies available for an unfair labor practice charge under the NLRA. In this case, the board expanded, I mean, they went beyond the Obama era board and expanded the remedies available to union members, but also employees for whom an unfair labor practice charge is successful. The board has now expanded the remedies from what they always had a remedy of make whole remedies. In other words, the idea is to place the person in the position he or she would have been in had they not been the recipient of an unfair labor practice. So normally we would see reinstatement, back pay, that sort of thing is what make whole remedies are all about. Well, the labor board now has ruled, again, as of December of last year, that make whole remedies are now going to be much, much broader. And they've introduced a lot of uncertainty into what that term is going to mean, because they have now determined that the board was going to, or did, revisit and clarify existing precedent for ordering relief. So they now have ruled that in any remedy, which includes an order for make whole relief, which is almost all of them, the relief must be specifically calculated, and the employer must compensate the affected employees for all direct or foreseeable pecuniary harms arising out of the unfair labor practice. Now, this led a lot of us to believe that meant a person who's been subject to an unfair labor practice can get compensatory damages, which means damages like we see in court cases for pain and suffering and emotional distress, etc., in which the sky's the limit. Although the board has said, they have to be reasonable, they have to be calculated by the general counsel. But this opens the door to a whole new subject of litigation over remedies for an unfair labor practice charge. This, of course, reflects the, maybe bias is too strong of a word, of the current labor board in favor of organized labor and employees. Because now, not only will we litigate the unfair labor practice, but we'll have to litigate much more extensively and with much uncertainty what this means. What this phrase foreseeable pecuniary harm means. That's where we have an ambiguity, and it's going to take cases to figure out what's permissible, what's not permissible, what the general counsel is going to ask for. I mean, this is, in my view, has huge impact on labor law and the unfair labor practice process and outcome. And my cynical attitude is that this was done not only to give somewhat of a gift to organized labor, but also to encourage more settlement of unfair labor practice charges to avoid this mini litigation we're going to have in an unfair labor practice case of what these so-called foreseeable pecuniary harms are. So this is going to be an interesting area, but it's also going to be costly for employers, and it's going to be very aggravating until we get enough cases decided that we know what's really going to be included. Because the board does say that as they put it, the implicit recognition of making employees whole should include at least compensating them for direct or foreseeable pecuniary harm. And that's now the standard. And then they go on to try to explain it a little bit, saying, hey, these aren't tort remedies. This isn't compensatory damages. And they talk about compensating for things that we would think of, out-of-pocket expenses. And then credit card, but now they're talking about credit card debts, other costs required to make ends meet if the person, for example, was discharged. And as they say, we cannot fairly say that employees have been made whole until they are fully compensated for these kinds of pecuniary harm that were direct or foreseeable consequences of the unfair labor practice. So we'll see how this plays out. But the concerns that those of us who represent management have are, where's the line going to be drawn? If I lose my job and I lose my home, is the make whole remedy now under this new standard going to include compensating me for the loss of the home, the interest on mortgage payments, If I developed an ulcer over this, am I now going to get my medical expenses? I mean, we just don't know for sure until we see how this plays out. Now, it's entirely possible this case could make it to the U.S. Supreme Court and we'll get some feedback, but I got to tell you, in my experience, the Supreme Court takes very, very few NLRB cases. So I suspect this is going to have to be battled out in front of the Labor Board and in the Circuit Courts of Appeals. So stay tuned on what this, on the impact of what this significant decision by the NLRB will be. Something that the next item, which deals with dues checkoff, this is something that's not surprising. And in fact, most of the employers I represent did it anyway. And what the board found is that when you're in collective bargaining and the collective bargaining agreement expires by its own terms, you still have to honor dues checkoff. So you still have to deduct dues of union members and remit them to the union, even though your contract has expired and there's nothing in the contract that says it continues until a successor agreement is made. So word to the wise, you must continue to deduct union dues through the checkoff programs when a collective bargaining agreement has expired. All right. Another case that I think we had foreseen in previous cases since the Biden board had become the majority, or the Democrats on the board had become the majority, has to do with employers who file suit against employees for things like, I've listed here, defamation, because they've, said something about management, maybe in negotiations or, in other contexts that are related to protected activity under the Act. Sometimes an unwise employer will file a breach of contract claim against an employee that's based on the collective bargaining agreement. In this particular case, the board decided back in September, it had to do with discovery in a defamation and breach of contract case. And the board adopted a rule, which really was not surprising, and I'm not even sure I disagree with it, but as if that matters. But the board has said now that if the employer files a lawsuit in state court and presumably federal court, files a lawsuit over subject matter that is preempted by the National Labor Relations Act, that in and of itself is an unfair labor practice. So these guys in this case, which was called Pain Relief Centers, they had filed a defamation and breach of contract case against an employee arising out of things that were said in collective bargaining. And so the board said, hey, if it's preempted under the Labor Relations Act, if you do that, it's an unfair labor practice charge. Now, just a bit about preemption. There are certain subject matters that the states cannot get involved in, and if state courts especially. And those matters are those items that are within the primary jurisdiction of the National Labor Relations Board. So if you sue somebody, well, I'll give you a perfect example. When Bill Clinton was president, he tried to issue an executive order that barred federal contractors from, I can't exactly remember what the subject matter was, but it was something that was well within the purview of the National Labor Relations Act and the board. And the courts unanimously held that you can't do that, and they voided the regulation because it was preempted by the National Labor Relations Act. It was within the primary jurisdiction of the act, so those things are preempted. So if I file a defamation case against an employee arising out of something said during collective bargaining, let's say, that would be preempted under the Labor Act, and therefore that case would have to be dismissed. But now it's also an unfair labor practice. So keep that in mind. I don't know of very many employers who have done that. Many aggressive employers might, but I don't think I've ever had an employer file a state court lawsuit against an employee arising out of a labor dispute. So that's something to keep in mind. Finally, and we'll get off the labor board, finally, on August 29th last year in a 3-2 decision, by the way, all of these are 3-2 decisions, the board issued a decision in a union insignia case, meaning that sometimes employees, and oftentimes employees, will want to wear something on their clothing at work that indicates that they're a member of a union, or that, you know, whether it's a pin or a button or a t-shirt or whatever. And in general, the law has always been essentially they're allowed to do that unless it interferes with the operations of the employer. Well, last August, the board overruled a decision by the truck board dealing with a case called Walmart, dealing with insignia, which made it easier for employers to demonstrate that wearing a union insignia did interfere with work. So in the Tesla case, this was a Tesla case, the board basically said, well, here's what we're going to do. We're going to go back to a 1945 case dealing with union insignia. And the board specifically stated that employees have a right to display union insignia. However, it's not an absolute right. There are conditions under which employers can reject that. Now, the board says there is a presumption that any employer limitation on the display of union insignia is invalid, which means that there's a heavy burden on an employer to establish special circumstances to justify banning union insignia in the workplace. It is a special circumstances test. And the board talks about, you know, for example, something like that might be safety, where the union insignia the employee wears might get caught in a machine, or, you know, presents some other kind of safety threat to the employee, co-workers, or the equipment of the employer. So the special circumstances are such that, as they say, justify restrictions, damage to the employer's product, for example. This had to do with mutilation of Teslas as they went through the production line. The board said that's really, they didn't really prove that. They do have a legitimate interest, but the evidence didn't support it. So just keep in mind that there is that any restriction on union insignias is presumptively invalid. So the employer has a high burden to show special circumstances that they should not be allowed to be worn. Okay, enough for the NLRB. I want to switch to the affirmative action, just make a quick comment. There are two cases before the U.S. Supreme Court. which are higher education cases. However, oftentimes we extrapolate from those cases to the employment context. And because the Supreme Court really hasn't addressed an employment case in years, but they do have 2 affirmative action cases from universities. And the smart money is on this conservative court invalidating affirmative action for the purpose of diversity. The court has always stuck by affirmative action as a remedy for proven discrimination, or I should say proved discrimination. Judges can use it to remedy discrimination that has been established by an employer or a university. Also, they have endorsed a somewhat limited affirmative action approach for not so much diversity reasons, but in a sense diversity reasons, but those have to be voluntary, those which are voluntary and for a limited time. The court has approved, and I don't think they're going to interfere with that. But I do think, just based on the composition of the court and the fact that they took these cases, we're about to see affirmative action in universities and other institutions of education change. Probably be scaled back, if not eliminated altogether. So keep an eye out on those, because sometimes they do have an impact on what we advise clients to do in the workplace. So especially if it deals with trying to diversify your workforce when no discrimination has been established, that your workforce is what it is because you discriminated. So keep an eye on those affirmative action cases. They were argued last term, so I suspect they'll be issued hopefully soon, but might not be till June. They seem to like to drop bombs at the end of the term often. All right, so that's affirmative action. Now, another item, which is item 3 on my list, is the PLAWA. That's only because I didn't want to type out the whole thing. But what that is this is an Illinois statute, but it's similar to statutes in a handful of other cases. So it's not just limited to Illinois for purposes of this presentation. And that is, it's called the Paid Leave for All Workers Act. A handful of states have this, and now Illinois has joined the group. And what it basically does is require all employers to give employees 5 days of paid leave per year for any reason whatsoever. And the employee does not have to give the employer a reason, and the employer cannot ask what the reason is for the leave. I mean, the employee can volunteer it, but they don't have to. And the employer can't ask. So it's 5 days off paid for any reason. Now, that has raised the concern of many employers in Illinois about, does that mean I have to give my employees 5 days more leave beyond the PTO they already have? And the answer is no. If you have a leave policy in effect that allows employees to take at least 5 days off for any reason, you don't have to change that based upon this statute, not yet anyway. We'll see what the regulations say that will be issued by the Illinois Department of Labor, but I don't think it's going to require employers who already have PTO or other types of leave to add 5 more days of paid leave. You just have to be sure that in your paid leave policies, you have at least 5 days people can take off for no reason or any reason at all. So for example, if you have 2 weeks of vacation that an employee has, the employee can say, hey, I'm going to take 5 vacation days, and that's it. They can use those days for anything, even if they tell you it's vacation. I think we're still okay. The nice thing about this is it doesn't go into effect until January 1st of next year. So we'll have regulations to look at. We'll have other expert analyses to review. But right now, the conventional thinking that I have seen is that as long as you have leave policies that enable an employee to take off 5 days with pay for any reason at all, you're covered by this, or you're not subject to this act. There are also some other exceptions, but we'll see what happens. I just wanted to alert people to it. If you live in a state that has one of these, you probably already had some experience with it, but Illinois has now joined the club. This is why we call Illinois the California of the Midwest. All right, a word or two, since we only have about 15 minutes left, about discrimination law. The hot topics right now seem to be the LGBTQ, and I know I left off a couple other letters, and I apologize for that. Cases about the accommodation for LGBTQ plus employees. So the Supreme Court, of course, has held that transgender status is protected under Title VII and presumably then under Title IX, Title VI, but that's not for sure. Excuse me. Back on December 16th of last year, the Second Circuit Court of Appeals decided a case called Soule, S-O-U-L-E, versus Connecticut Association of Schools, Inc., which challenged the participation in high school sports of transgender girls. Ms. Soule was actually a minor who was represented by her mother, not represented as an attorney, but as sort of guardian parent, and challenged the Connecticut State Athletic Association, or Interscholastic Athletic Conference, and the schools, some of the high schools, that permitted transgender girls to participate in high school sports with non-transgender girls. And of course, you don't have to think too hard to figure out what the challenge was, and that is that it put the non-transgender girls at a disadvantage. We've seen a lot of that in the media. It's gotten a lot of attention on social media and in the news. And these folks filed a lawsuit saying, hey, this violates Title IX because you're discriminating against the girls in favor of transgender girls. And it is unfair, violates Title IX. And so the Second Circuit, in a rather gigantic opinion, not gigantic, I mean, it was 29 pages of the majority opinion. We had a couple of, there were some dissents, but the point is the court ruled this is okay, that it doesn't violate Title IX, it doesn't violate the Equal Protection Clause of the 14th Amendment, that it is legally okay. Now, and that was a decision, as I said, rendered in December, and we'll see what happens. My guess is, excuse me, the plaintiffs in the case who lost will seek review by the U.S. Supreme Court. And, I can't help but think that at some point, maybe not this term, but maybe next term, the Supreme Court is going to have to take a look at this issue, because on December 30th, just 2 weeks after the Connecticut decision in the Second Circuit, the 11th Circuit Court of Appeals ruled in not a similar case, but somewhat, dealing with the Title IX issue of the use of bathrooms. There was a Florida school that had a policy that you had to use the bathroom consistent with the gender as you were born, your birth gender, what is called assigned at birth, for lack of a better term. And a transgender girl challenged that. Now, the Florida schools had a policy, excuse me, the school board had a policy that there also was available a neutral bathroom, a non-gender bathroom, if you will, that trans students could use. But the transgender girl in this case wanted to use the girls' room, the girls' bathroom. And there was a challenge by one girl by the name of Drew Adams to this, saying that this is a violation of Title IX. And the 11th Circuit held that, yes, it is. Now, among other reasons, the 11th Circuit said it violates Title IX because Title IX has an exception that having separate bathrooms for boys and girls, men and women, is acceptable under Title IX. So that was part of the reason why the court in this case held there was no violation of Title IX. Now, it's a lot more detailed than that. Both these cases are very thorough, especially the 11th Circuit case, because the judge who dissented wrote an opinion longer than the majority opinion. So interesting reading both. So the 11th Circuit is Adams versus School Board of St. Johns County, Florida. So now we have not an exact split in the circuits of how this issue of transgender participation in sports and use of bathrooms are at opposite ends of the spectrum. Both involve Title IX. So I suspect that the Supreme Court is going to have to take up this issue, if not this term, then next year's term. So we'll see. This is really something to keep an eye on. Now that we have two Circuit Court of Appeals opinions, one of these is going to make it to the Supreme Court, if not both. So this is something to really keep an eye on, because this is a real life issue for employers. You know, if you have transgender employees, these issues are going to come up under Title VII. And and if it's a private university, it's going to come up probably under Title VI as well. But keep an eye out on how these cases are going, because this is going to be and continue to be a big issue, not just in schools, but also in the place of employment. All right, finally, in the few minutes we have left, the joint employer doctrine. Okay, what is this about? What's the hubbub here? Well, the hubbub here is that the EEOC, the Department of Labor, and the NLRB all are changing the Trump era definition of joint employer and joint employee. This is called the joint employer doctrine, and it's to determine if an employer other than the employer for whom the employee works should also be deemed an employer for purposes of charges filed, for litigation, for remedies, the whole 9 yards. So the Trump administration had a multifactorial test that I kind of thought was reasonable, but then, again, I'm a management attorney. And so now all three of these agencies that are controlled now by the Biden administration have moved to a different test. They loosely call it the economic realities test, but I think it's different from the economic realities test that we are familiar with dealing with. But in the interest of time, all three of these agencies now define a joint employer by determining to what extent the purported joint employer or co-employer, as they put it, shares control over or co-determines the employee's essential terms and conditions of employment. So that's, again, going to produce a lot of litigation when the EEOC or the Department of Labor or the NLRB tries to hold an employer other than the direct employer for whom the employee works liable under the statutes they administer. So if you have an employee who works for you, but someone else determines, in part, co-determines the terms and conditions of employment under this new test, they're most likely going to be a co-employer. This has franchises very worried because all these agencies have tried to rope in franchisors like McDonald's and the like to be co-employers of employees who work for franchisees because they're the deep pocket. So this is an area to really keep an eye on, especially for employers that contribute to or help define the terms and conditions of someone else's employees, like a vendor. You can see all the applications here. So, if we don't have enough to worry about, now this is becoming reality. And, if a Republican wins in 2024, it's all going to change anyway. So I hope that in the time we have spent together this morning, you have found something helpful in the presentation. Again, let me thank each and every one of you for participating, and thank Higher Level again for its sponsorship of this webinar. Thank you, Erin, and thank you all who have participated.
Thank you so much, John. I hope everybody enjoyed the presentation today. Again, thank you for your time. Before I kick off in talking about more about what we're doing in February, I just want to make sure everyone on the call today had my contact information. Would love your feedback on what you thought of the presentation today and any other topics that you would like to see throughout this year. Obviously, we want to tailor that content to our viewers and make sure that we are maximizing our resources to give you that best information. And so that's what we're here for. So you can reach me directly at hello@higherlevel.com. Connect with me on LinkedIn. We will be sending a survey out following the webinar that I also would love for everyone to participate in to provide that feedback. Again, we can only be better because of you. Next month we have coming up on February 15th, another Higher Level partner covering the 3 key steps to lead and motivate your team. So that will be a great topic. Shad always provides good information for Higher Level, and I know you all can provide that to your teams as well. So look forward to hearing some feedback from all of you. Again, reach out and let me know if there's anything that you would like to hear from Higher Level and our trusted partners, and I can do my best to get it on our list for this year. Thank you again, everybody, and have a great rest of your day.